All right. So we talked last time about issues with civil liberties, and we ended with discussing civil rights for prisoners, the issues that they have faced in terms of treatment within Texas prisons. So now we'll get to the great behemoth that is capital punishment in Texas. I talked a little bit about this in Chapter 9, but it's worth it to go back over it again. The death penalty in Texas is applicable only to homicide cases. So it's applicable to homicide with aggravating circumstances, such as murdering a peace officer or firefighter, murder for hire, and the murder of a child under the age of 6. Aggravating circumstances is where they add, basically it becomes an automatic death penalty case. Statistically speaking, the death penalty is supported here in Texas. 73% of Texans across the board tend to support the death penalty. 75% of white Texans favor the death penalty. 63% of African Americans, and 71% of Latinos. This is a little surprising because when you look at the death penalty nationally, minorities don't tend to support it at as high of levels compared to whites outside of states like Texas. It's a little bit of a unique kind of situation we see here in Texas. Now, after 1976, because of Supreme Court decisions, the death penalty is no longer allowed in non-homicide cases. So, if you rape someone, it's no longer a death penalty case. There has to be a murder for the death penalty to apply. You also can't automatically impose the death penalty for the murder of a police officer, for example. It has to be debated. The prosecutor can push for the death penalty, but it can't be the final result before the trial even begins. Also, juries now have more of a say in whether or not the death penalty gets imposed. There have been cases where the jury finds the defendant guilty, and then the death penalty is imposed, and the jurors later say, if we'd known this person was going to be executed, we wouldn't have found them guilty. So now juries get to decide if the death penalty applies or not. They can't automatically bar someone from serving on a Texas jury if they're opposed to the death penalty. So they can't just automatically be like, oh, you don't like the death penalty, you're off the case. Between 1982 and 2019, 560 people were executed in the state of Texas. Which means, statistically speaking, we do execute the most people in the United States. Given the popularity of the death penalty, that's unlikely to change unless somehow there's a change in laws or attitudes going forward. Okay. It used to be the case that a life sentence meant automatic eligibility for parole after 40 years. which is why John Barry was involved in the murder of James Byrd Jr. is eligible for parole in 2038 because at the time of his sentencing, life sentence meant possibility of parole after 40 years. What was happening was more people were being executed because juries didn't want them to be eligible for parole. Now that you can impose life without the possibility of parole, that has changed the death penalty a little bit. Also, Texas used to execute prisoners who were under the age of 18 when convicted. In 2002, the state executed 3 men who had been 17 when they committed murder. The Supreme Court has said you cannot do that. Biologically speaking, our brains are not fully formed until at least 21. If you're under 18 when you commit a murder, the brain hasn't fully formed yet. It's hard to say we should treat them the same as a fully grown adult when they're not actually there yet. It's no longer allowed. So 28 prisoners in Texas had their sentences commuted to life rather than death. And the Supreme Court is also looking at, can you sentence a defendant under the age of 18 to life without the possibility of parole? There's an argument that that's a violation of the 8th Amendment. Because if you're 17 and you get life in jail, that's life, right? You're literally going to grow up, you're old, and die in jail. So the Supreme Court is looking at that, saying, should we do that? We don't know. We do have some problems with how our Court of Criminal Appeals works. Last-minute appeals are supposed to be heard. If someone is to be executed and they file a last-minute appeal, a judge needs to look at that. And in 2007, Judge Keller decided that she would close the court at 5 p.m. rather than hear a last-minute appeal for a prisoner who was executed that night. You can't have that happening. The appeals process has to exhaust itself. They have to be given the chance to appeal all the way up to the Supreme Court if possible. There could have been grounds for a legitimate appeal, but because she chose to close the court, she didn't get that chance to appeal his execution. So you can't do that, right? You can't close the court. You need to hear that appeal. The other problem we see, of course, is what happens when DNA evidence proves that someone wasn't responsible. You can't bring someone back from the dead. You can't give them back 40 years of their life either, but at least they're still alive. So that gets into the question of how can we make pretty damn certain that we're not executing an innocent person. There's no 100% guarantee, but we gotta at least try to make sure that doesn't happen. It is partly why people can be on death row for 20 or 30 years, because not to go over the evidence. People recant their stories. Eyewitness testimony changes. Things happen. So you don't want the state executing someone who's innocent, although that does unfortunately happen. Okay, any questions online before I move on? So, a slightly different but still related civil liberties, civil rights issue is tort reform. Most people looking at the law, it's kind of like watching paint dry. Not exactly fascinating, but it is important. Tort law deals with a private or civil wrong as the result of a legal breach of duty. This is a civil case. More often than not, it's going to result in a fine. If there's major malpractice, it can become a criminal case. But most of the time, it's a lawsuit against someone who hurt you. Doctors and businesses weren't happy with the amount of money Texans were winning in malpractice suits. They argued that it was pushing doctors out of the state and thus limiting consumer choices. If you don't have a lot of choices about who you see for your doctor, that's not exactly good. On the other hand, the lawyers and the consumer group said, look, you're basically trying to let these people off the hook. If a company knowingly hands out a dangerous product, if a doctor walks into surgery drunk, why shouldn't they be held accountable? If a doctor leaves a scalpel inside your body after surgery, shouldn't they be held accountable for that? I mean, it's more common than not that something gets left behind after surgery. Gauze, bandages, the occasional scalpel, believe it or not. It's a little scary because this can cause permanent damage to your body. So the argument against it was, well, if they screw up, shouldn't they be held accountable? If you knowingly sell a defective product, why can't we hold you accountable for that? Why shouldn't you be punished if you show up to do surgery while high on cocaine? But in the end, the doctors and businesses won. What happened is there's a limit of punitive damages, $200,000. So basically, there is a cap on how much you can get in punitive damages. You also have to file the lawsuit in the county where the injury occurred. If it happened in Hidalgo County, you can't file in Bexar County. More importantly, and unfortunately, if you're going to sue a doctor or a hospital, you have to put up a $5,000 bond first, which essentially does make it harder to sue. Also, after 2003, it limited our ability to file a class action lawsuit, grant immunity to a company whose product met government standards. So if you sue because of the side effects of a drug, but it was cleared by the FDA, you're out of luck. They limited the fees lawyers can get in certain cases. Most importantly, if you're offered a settlement before the trial and you decline it, you're going to get penalized for it even if you later win the case. So if they offer you a settlement of $5,000, you say no, and you later get $100,000, you still have to pay a penalty because you didn't accept that pre-trial settlement. Also, the amount you can get for pain and suffering is capped at $250,000. So it is very, very hard to sue a doctor or a business in Texas. I know those who support it will argue that doctors are no longer leaving the state. We have more access to health care, better choices. The opponents say, look, insurance rates were never tied to tort reform, but changes in the healthcare market. Also, you're now basically telling the victims of negligence that, too bad, we're not going to help you, you're on your own. Unfortunately, because torts are not in the Constitution on the federal level, for the most part, any challenges to Texas law get turned down by the federal courts. The reality is, here in Texas, if you are hurt by a doctor, you're limited in what you can get from them. For better or worse, this is the reality of lawsuits in Texas. You're just not going to do as well compared to other states where there may not be that cap. Did someone have a question? I thought I heard something. No questions? So before I stop the recording to show the documentary, next week we will start on chapter 11. Also keep in mind your research paper is due 1 week from today in Blackboard by 11:59 p.m. You have 1 week left, so if you haven't written the paper, you maybe work on that. If you've already turned it in, I probably won't look at it until after the 11th, but you're good to go if you've already turned it in. Any questions on the paper? Okay. So for those of you who are online, this is the link to the documentary in YouTube that I'm going to show here in the classroom, so you can watch it on your computers. I'm going to stop recording the class now to avoid any issue of copyrights for YouTube. But this part of the lecture will be available online later, and you can just watch the documentary in YouTube now or at your own convenience.